The self-defense statute in Indiana, 354132 is their coding system there. 35 being Title 35, Criminal Law and Procedure, Article 41, Crimes, Chapter 3, Defenses, 2, Culpability. So self-defense, of course, is a physical act. That's how many of us think of it, right? So we're attacked, we defend ourselves, an act of self-defense, but it's also a legal defense. It's a legal defense that you raise to a use of force criminal charge or civil claim. And it's a perfect defense, self-defense. So if you're successful in your defense, you have zero criminal liability. It doesn't just mitigate your liability, criminal and civil. It eliminates it. What you did was simply not a crime. It simply was not a violation of a legal duty for which you would be civilly liable. But it's very binary. The legal defense is self-defense. Either you qualify or you don't. It's like a light switch that's on or off. Either you have zero legal liability because your claim of self-defense was deemed valid, or your claim of self-defense was defective. You're missing one of the required elements of a claim of self-defense, and you have 100% criminal liability, 100% civil liability for whatever damages you caused, wrongful death, whatever the case may be, and 100% criminal liability, which could mean life in a cage without possibility of early release. So the first chapter of this statute is really a statement by the legislature. We want it understood that this is how we feel about self-defense for the residents of Indiana. It's not the kind of thing that would normally be communicated to jurors in a jury instruction, although I have seen states that say this statement of intent by the legislature should be read to the jury. This should be part of the jury instruction. But unless the statute explicitly says that, it wouldn't typically be part of a jury instruction. And in which case, it's just kind of feel-good language for the legislature's own benefit. But it reads, in enacting this section, the General Assembly, the legislature of Indiana, finds and declares that it is the policy of this state to recognize the unique character of a citizen's home and to ensure that a citizen feels secure in his or her own home against unlawful intrusion by another individual or a public servant. So this is interesting already because, for one thing, it tells us that at least part of the statute is going to be about what? Defense of highly defensible property against unlawful intrusion into the highly defensible property. So that's not the only thing the statute covers. It also covers straight up self-defense as if you were walking down the street. But it's going to, at some point, specifically refer to use of force in defense of highly defensible property, your home, against a unlawful intrusion by either some other individual or a public servant. So one of the notable things about the Indiana self-defense law is it spends quite a bit of time talking about, one, the fact that there are circumstances in which you can use force against a public servant, like a police officer, and have that be lawful, and specifying what those circumstances are. Now, it's almost always the case that you can use force against a public servant, against a police officer, under the appropriate circumstances. If that officer is attempting to use unlawful force on you, for example, you'd be privileged to use force in self-defense against that unlawful force, just like you have a privilege to use force against any unlawful force that you're being threatened with or that's being used against you. Now, the trick with law enforcement, of course, is they have a lot of privilege to use lawful force, to be the initial aggressors in the course of their duties in making an arrest. Normally, other people don't have any privilege to use force against you as the initial aggressor, as the initiator, right? But police officers do, depending on whether it's being done within the lawful boundaries of their legal duties. If an officer is using excessive force, unlawful force upon you, then you have a privilege to defend yourself against that unlawful force. That's really true in every state, but most states don't make it as explicit in their statutory code as does Indiana here. Continuing, by reaffirming the long-standing right of a citizen to protect his or her home against unlawful intrusion, however, the General Assembly does not intend to diminish in any way the other robust self-defense rights that citizens of this state have always enjoyed. So it's not just about the home. There's other self-defense rights as well. Accordingly, the General Assembly also finds and declares that it is the policy of the state that people have a right to defend themselves and third parties, others, from physical harm and crime. The purpose of this section, the statute, is to provide the citizens of the state with a lawful means of carrying out this policy. Provisions concerning civil immunity for the justified use of force as defined in the self-defense statute are codified in statute 3430-31. I think it's 31-1. That's the self-defense immunity statute we're also going to look at today. So that's the introductory paragraph A. Paragraph B, as used in this section, public servant means, and I'm not going to click over to there, but there's obviously statutory definitions of what would qualify as a public servant for purposes of this self-defense statute. And here we have the straight up self-defense law. Now, this is not defense of home language here in paragraph C. This is just, you're in public on the street, public space, you're attacked, you defend yourself. These are the elements of that, not specific to highly defensible property, self-defense privilege. A person is justified in using reasonable force against any other person to protect themselves or a third person from what they reasonably believe to be the imminent use of unlawful force. Okay, straight up, we see a number of elements there. First of all, I'll point out reasonableness, very common. And of course, reasonableness is one of the elements of self-defense. Very common to see reasonableness referred to multiple times throughout a self-defense statute, often multiple times in a single sentence. So I just read the first sentence from paragraph C, the straight up self-defense law of Indiana, and it refers to reasonable twice in one sentence. And we'll see further references to reasonable. That reflects the weight and importance that self-defense law places on that fifth element of reasonableness. And of course, reasonableness is both subjective and objective. So it has two facets. You need to have both of them for the element of reasonableness to be satisfied. One is a subjective reasonableness. You have to have had a genuine good faith, subjective belief in the need to use force in self-defense and your perceptions of the threat and so forth. But that subjective belief by itself is not enough. No matter how genuine, no matter how good faith, it's not sufficient if it's irrational or speculative or imaginative, because the other half of reasonableness is objective reasonableness. That subjective belief has to be objectively reasonable, meaning a hypothetical, reasonable, and prudent person would have shared that belief. It's based on the application of powers of reason to actual evidence. Evidence from which you can make a reasonable inference that you were facing a threat. So you use deadly force upon somebody because they're threatening you verbally, which by itself is not enough, but then they reach for their waistband as if reaching for a weapon. Well, you may not see a weapon. You don't necessarily have to wait to see a weapon. You're making a reasonable inference that the combination of the verbal threat of deadly force and their conduct consistent with someone accessing a weapon to carry through that threat, that would provide a reasoned basis for believing you're facing a deadly force threat. As opposed to, well, for all I know, he could have had a gun, or for all I know, he could have had a knife, or there's a verbal threat alone and there's no physical conduct consistent with an apparent intent to carry out that verbal threat. Verbal threats alone, if that's all there is, not sufficient to justify deadly force in self-defense.